Rule 9. Effect of failure to plead. Section 1. Defenses and objections not pleaded. Defenses and objections not pleaded, either in a motion to dismiss or in the answer, are deemed waived. However, when it appears from the pleadings or the evidence on the record that the court has no jurisdiction over the subject matter, that there is another action pending between the same parties for the same cause, or that the action is barred by a prior judgment or by statute of limitations, the court shall dismiss the claim. Section 2. Compulsory counterclaim or cross-claim, not set up, barred. A compulsory counterclaim or a cross-claim not set up shall be barred. Section 3. Default, declaration of. If the defending party fails to answer within the time allowed therefor, the court shall, upon motion of the claiming party, with notice to the defending party, and proof of such failure, declare the defending party in default. Thereupon, the court shall proceed to render judgment granting the claimant such relief as his or her pleading may warrant, unless the court in its discretion requires the claimant to submit evidence. Such reception of evidence may be delegated to the clerk of court. A. Effect of order of default. A party in default shall be entitled to notices of subsequent proceedings, but shall not take part in the trial. B. Relief from order of default. A party declared in default may at any time after notice thereof and before judgment file a motion under oath to set aside the order of default upon proper showing that his or her failure to answer was due to fraud, accident, mistake, or excusable negligence, and that he or she has a meritorious defense. In such case, the order of default may be set aside on such terms and conditions as the judge may impose in the interest of justice. C. Effect of partial default. When a pleading asserting a claim states a common cause of action against several defending parties, some of whom answer and the others fail to do so, the court shall try the case against all upon the answers thus filed and render judgment upon the evidence presented. D. Extent of relief to be awarded. A judgment rendered against a party in default shall neither exceed the amount or be different in kind from that prayed for, nor award unliquidated damages. E. Where no defaults allowed. If the defending party in an action for annulment or declaration of nullity of marriage or for legal separation fails to answer, the court shall order the Solicitor General or his or her deputized public prosecutor to investigate whether or not a collusion between the parties exists, and if there is no collusion, to intervene for the state in order to see to it that the evidence submitted is not fabricated. Rule 10. Amended and Supplemental Pleadings. Section 1. Amendments in general. Pleadings may be amended by adding or striking out an allegation, or the name of any party, or by correcting a mistake in the name of a party, or a mistaken or inadequate allegation, or description in any other respect, so that the actual merits of the controversy may speedily be determined without regard to technicalities, in the most expeditious and inexpensive manner. Section 2. Amendments as a matter of right. A party may amend his or her pleading once as a matter of right at any time before a responsive pleading is served or, in the case of a reply, at any time within 10 calendar days after it is served. Section 3. Amendments by leave of court. Except as provided in the next preceding section, substantial amendments may be made only upon leave of court, but such leave shall be refused if it appears to the court that the motion was made with intent to delay, or confer jurisdiction on the court, or the pleading stated no cause of action from the beginning which could be amended. Orders of the court upon the matters provided in this section shall be made upon motion filed in court, and after notice to the adverse party, and an opportunity to be heard. Section 4. Formal Amendments. A defect in the designation of the parties and other clearly clerical or typographical errors may be summarily corrected by the court at any stage of the action, at its initiative or on motion, provided no prejudice is caused thereby to the adverse party. Section 5. No amendment necessary to conform to or authorize presentation of evidence. When issues not raised by the pleadings are tried with the express or implied consent of the parties, they shall be treated in all respects as if they had been raised in the pleadings. No amendment of such pleadings deemed amended is necessary to cause them to conform to the evidence. Section 6. Supplemental Pleadings. Upon motion of a party, the court may, upon reasonable notice and upon such terms as are just, permit him or her to serve a supplemental pleading setting forth transactions, occurrences, or events which have happened since the date of the pleading sought to be supplemented. The adverse party may plead thereto within 10 calendar days from notice of the order admitting the supplemental pleading. Section 7. Filing of amended pleadings. When any pleading is amended, a new copy of the entire pleading, incorporating the amendments which shall be indicated by appropriate marks, shall be filed. Section 8. Effect of amended pleadings. An amended pleading supersedes the pleading that it amends. However, admissions in superseded pleadings may be offered in evidence against the pleader, and claims or defenses alleged therein not incorporated in the amended pleading shall be deemed waived. Rule 11. When to file responsive pleadings. Section 1. Answer to the complaint. The defendant shall file his or her answer to the complaint within 30 calendar days after service of summons, unless a different period is fixed by the court. Section 2. Answer of a defendant foreign private juridical entity. Where the defendant is a foreign private juridical entity and service of summons is made on the government official designated by law to receive the same, the answer shall be filed within 60 calendar days after receipt of summons by such entity. Section 3. Answer to amended complaint. When the plaintiff files an amended complaint as a matter of right, the defendant shall answer the same within 30 calendar days after being served with a copy thereof. Where its filing is not a matter of right, the defendant shall answer the amended complaint within 15 calendar days from notice of the order admitting the same. An answer earlier filed may serve as the answer to the amended complaint if no new answer is filed. This rule shall apply to the answer to an amended counterclaim, amended cross-claim, amended third, fourth, etc. party complaint, and amended complaint in intervention. Section 4. Answer to counterclaim or cross-claim. A counterclaim or cross-claim must be answered within 20 calendar days from service. Section 5. Answer to third, fourth, etc. party complaint. The time to answer a third, fourth, etc. party complaint shall be governed by the same rule as the answer to the complaint. Section 6. Reply. A reply, if allowed under Section 10, Rule 6 hereof, may be filed within 15 calendar days from service of the pleading responded to. Section 7. Answer to supplemental complaint. A supplemental complaint may be answered within 20 calendar days from notice of the order admitting the same, unless a different period is fixed by the court. The answer to the complaint shall serve as the answer to the supplemental complaint if no new or supplemental answer is filed. Section 8. Existing counterclaim or cross-claim. A compulsory counterclaim or a cross-claim that a defending party has at the time he or she files his or her answer shall be contained therein. Section 9. Counterclaim or cross-claim arising after answer. A counterclaim or a cross-claim which either matured or was acquired by a party after serving his or her pleading may, with the permission of the court, be presented as a counterclaim or a cross-claim by supplemental pleading before judgment. Section 10. Omitted counterclaim or cross-claim. When a pleader fails to set up a counterclaim or a cross-claim through oversight, inadvertence, or excusable neglect, or when justice requires, he or she may, by leave of court, set up a counterclaim or cross-claim by amendment before judgment. Section 11. Extension of time to file an answer. A defendant may, for meritorious reasons, be granted an additional period of not more than 30 calendar days to file an answer. A defendant is only allowed to file one motion for extension of time to file an answer. A motion for extension to file any pleading other than an answer is prohibited and considered a mere scrap of paper. The court, however, may allow any other pleading to be filed after the time fixed by these rules. Rule 12. Bill of Particulars. Section 1. When applied for. Purpose. Before responding to a pleading, a party may move for a definite statement or for a bill of particulars of any matter, which is not averred with sufficient definiteness or particularity to enable him or her properly to prepare his or her responsive pleading. If the pleading is a reply, the motion must be filed within 10 calendar days from service thereof. Such motion shall point out the defects complained of, the paragraphs wherein they are contained, and the details desired. Section 2. Action by the court. Upon the filing of the motion, the clerk of court must immediately bring it to the attention of the court, which may either deny or grant it outright, or allow the parties the opportunity to be heard. Section 3. Compliance with order. If the motion is granted, either in whole or in part, the compliance therewith must be effected within 10 calendar days from notice of the order, unless a different period is fixed by the court. The bill of particulars or a more definite statement ordered by the court may be filed either in a separate or in an amended pleading, serving a copy thereof on the adverse party. Section 4. Effect of non-compliance. If the order is not obeyed, or in case of insufficient compliance therewith, the court may order the striking out of the pleading or the portions thereof to which the order was directed, or make such other order as it deems just. Section 5. Stay of period to file responsive pleading. After service of the bill of particulars or of a more definite pleading, or after notice of denial of his or her motion, the moving party may file his or her responsive pleading within the period to which he or she was entitled at the time of filing his or her motion, which shall not be less than 5 calendar days in any event. Section 6. Bill, a part of pleading. A bill of particulars becomes part of the pleading for which it is intended.